The building owner I worked for 6 years forged my signature on illegal receipts. I found out when a tenant came to complain about a charge I never made. What I found when I started looking was worse than I imagined. There are jobs where trust is the condition of everything else. Not because it is written in any contract, but because the nature of what you do requires that the person you work for and the people you work with assume that you are who you say you are and that you act the way you say you act. Being a building manager is that kind of job. You are the visible face of something someone else owns. Your name is on the contracts. Your signature is on the receipts. Your phone number is the one people call when something does not work. And when someone decides to use that position to do something that should not be done, you are the one who is exposed, not the owner. You. That is what I discovered on a Wednesday in March when a tenant arrived at the building management office with a folder of documents and the contained fury of someone who had spent weeks processing an anger they could no longer keep containing. My name is Renata. I am 44 years old. I am a property manager with 16 years of experience, and during 6 of those 16, I had worked for a property owner I'm going to call Mr. Fuentes because his name is part of a legal process that still has open chapters. Mr. Fuentes was 61 years old when all of this occurred. He owned a building of 24 apartments in a middle-class residential area. He had the reputation of a serious landlord who maintained his properties well and who paid on time. 6 years of work without a single problem I knew of. 6 years of my name on every document in the building. 6 years of being the person the tenants trusted. That was also what was at risk when Mr. Fuentes decided to do what he did. The tenant who arrived that Wednesday was named Mr. Arturo. He was 63 years old. He had been in the building for 4 years. He arrived with a folder. He told me he needed me to explain why for the past 16 months I had been charging him an additional 1,200 pesos every month above his official rent. I told him I did not understand what he was referring to. He told me that every month after paying his official rent by bank transfer, he received a visit or a call requesting an additional cash payment for varying concepts: special maintenance, building reserve fund, services update. That he had paid because whoever was charging him told him it was part of the new management scheme I had implemented. That he had kept all the receipts. That on those receipts my name appeared. And my signature. He opened the folder. He placed 16 receipts on the desk in front of me. With my name. With a signature that resembled mine, but was not mine. With the building management stamp that was real because Mr. Fuentes had access to it. I looked at those 16 receipts for a time that Mr. Arturo respected in silence. Then I raised my eyes and told him those receipts had not been issued by me. That the signature was not mine. That I had not charged any additional amount to any tenant at any point in the 6 years I had been in the building. Mr. Arturo looked at me the way someone looks at you when they do not know whether to believe what they are hearing, because what they are hearing completely changes the picture of what they had understood. I told him I needed him to lend me those receipts. That I would make copies and return them to him that same day. That what he had just shown me was very serious information and that I needed to understand the complete extent before telling him anything else. Mr. Arturo nodded. He left the receipts. And when I closed the management office door, I was alone with 16 documents that had my name and that I had never produced. The first thing I did was photograph every receipt. The second was call my attorney. Her name is Monica. She has spent 20 years in civil and labor law and has handled property and management dispute cases. I had hired her 2 years earlier to review my contract with Mr. Fuentes, and since then had kept her as a reference for any situation requiring legal judgment. I sent her photos of the receipts by message before calling her. When she answered, she had already seen them. The first thing she told me was not to talk to Mr. Fuentes yet. That before any confrontation, we needed to understand the extent. That if this was what it appeared to be, talking to him before having complete documentation would give him time to prepare a position. I told her I understood. She told me the second thing was to find out whether Mr. Arturo was the only affected tenant or whether there were more. Finding out whether there were more affected tenants required doing it in a way that did not generate panic in the building or alert Mr. Fuentes. What I did was what any building manager does as ordinary practice. Visit apartments under the pretext of a routine services review. In 2 days, I visited 18 of the 24 apartments. In 7 of them, when I asked indirectly about their experience with payments and whether they had any concerns about charges they had received, the response told me there was something. 4 tenants had received additional charges similar to Mr. Arturo's. 2 had paid without keeping receipts. 1 had complained at the time and had been told it was a temporary charge that was going to be regularized. All of them assumed I was the one charging, because on the receipts my name appeared. The file Monica and I built over the following 4 days contained the 16 receipts from Mr. Arturo with signature analysis that Monica commissioned from a handwriting expert, written statements from 4 additional tenants describing the charges they had received, the original contract between me and Mr. Fuentes specifying my functions and responsibilities and which did not include any authority to charge amounts beyond those established in the lease agreements. The lease agreements of the affected tenants, confirming that the additional amounts had no contractual basis. The handwriting expert's analysis, determining that the signature on the receipts was an imitation of mine, but not my signature. And an approximate calculation of the total amount charged irregularly in documented cases, approximately 84,000 pesos in the identified period, with the possibility that the actual period was longer and the amount higher. The meeting with Mr. Fuentes was formally convened by Monica in writing, not as an invitation, as a notification that there was a legal matter requiring his presence. He arrived with his own attorney. What followed was a 2-hour meeting that Monica conducted with the precision of someone who knows every element of what they have on the table. Mr. Fuentes listened to the presentation of the file. His attorney took notes. When Monica finished, Mr. Fuentes said the additional charges had been to cover extraordinary building expenses that were not budgeted and that he had decided to distribute among the tenants informally. Monica asked him why those receipts carried my name and an imitation of my signature instead of his. Mr. Fuentes said it was an administrative error. Monica presented the handwriting expert's analysis. She said a handwriting expert would not call a deliberate imitation an administrative error. Mr. Fuentes' attorney requested a recess. The negotiations that followed lasted 3 weeks. I'm not going to go into all the details because some form part of an agreement with confidentiality terms. What I can say is the essential. Mr. Fuentes acknowledged in the agreement that the charges had been made without my knowledge or authorization and that the use of my name and signature on the receipts had been improper. That declaration was fundamental to me because it was what formally and documentedly protected my professional reputation. The affected tenants received reimbursement of the irregularly charged amounts. I received compensation for the documented professional and reputational damage. I ended my working relationship with Mr. Fuentes that same day. What followed for me professionally was a period of reconstruction that I am not going to romanticize. 6 years of work in a building are 6 years of references, of relationships with tenants, of professional history linked to that name and that address. When that relationship ends in this way, there is a repositioning work that takes time. I contacted each of the building's tenants individually to explain what had happened and to leave clear the record of what my conduct had been during 6 years versus what had occurred without my knowledge. Most responded with the generosity of people who had had 6 years of direct interaction with me and who knew how to distinguish between what I was and what had happened. Mr. Arturo was the first to write to me. He told me he had known from the beginning that something did not add up because in 6 years I had never acted that way, and that was why he had decided to confront it directly. I thank him for having done it. Without that folder of receipts, everything would have continued the same. And at some point, when something had gone more wrong than it already had, I would have been the first to be exposed. What I want you to take from this story has very practical parts for anyone who works in a position where their name and signature represent another person or an institution. The first, periodically audit the documents circulating with your name, not only those you produce, those circulating in the environment where you work that carry your name even if you did not produce them. In representation positions, this is your responsibility because you're the one who answers if something goes wrong. The second, build direct relationships with the people you work with, in this case the tenants, so that if something irregular occurs, they come to you directly. Mr. Arturo came to me because in 6 years I had built enough credibility that he believed it was possible there was an error or an explanation. If he had not had that direct relationship, he might have simply decided not to renew and never said anything. The third, if you discover that your name or signature are being used on documents you did not produce, do not confront whoever did it before having complete documentation. Documentation first. Confrontation afterward, with legal representation present. And the fourth, reputational damage in jobs where trust is the main asset can be repaired if the response is fast, documented, and honest. It is not always fully reparable, but transparency with the affected people is what determines how much of that reputation can be recovered. If this story impacted you, comment. Do you regularly audit the documents circulating with your name at work? Like if you believe using an employee's name and signature to cover irregular activities should have more severe legal consequences. Subscribe for more real stories. Share with someone who works in a representation position and has never thought about this specific risk. Practical tip. If you work in a position where your signature appears on documents regularly, consider keeping a personal log of every document you sign with date and description. It is a simple habit that, if needed, allows you to demonstrate what you signed and what you did not. It is also useful to keep digital copies of all documents you signed stored in a space only you control.